you see. It'll be established on flimsy grounds. And so, that's the concern that they had. And so, this is Qawaid al-Usul. Now we get into a summary of the sources of law, right? And this, this is from Sheikh Hatim al-Awni from his book Ikhtilaf al-Muftin. And this book, Ikhtilaf al-Muftin, it's a book on different scholars disagreeing on furu'i issues, and how someone who's a non-specialist, a non-scholar, like how does he arrive at a particular conclusion? How does he know which scholar to follow? But based on the nature of that topic, the book itself, Ikhtilaf al-Muftin, is an usuli work. So there are a ton of usuli discussions and topics within the book itself. And so he has a section where he very briefly, it's only one page, just above a page, right, where he discusses the adillatul ahkam over here, and he gives a very neat summary, very, very neat summary. And we've got, so I've mentioned them in the next two slides. And this is extremely important, right? This is extremely important. These two slides they're essentially a summary of everything that we're going to cover. And so what does Sheikh Hatim al-Awni say when he's summarizing the usul and the topics that we listed before? He says, إذ من المعلوم أن مصادر السلف المتفق عليها هي القرآن الكريم والسنة المشرفة والإجماع والقياس. That if you look at, it's known that the sources of the early scholars and the early generations that are agreed upon are four. They're four. They're the Quran, they're the Sunnah, the Ijma' and Qiyas, right? وهذه المصادر, these four, وهذه المصادر مقطوع بها. That these are conclusive sources. These four in particular, they're conclusive sources. والخلاف في كونها مصادر التشريع خلاف غير معتبر ولا سائغ لأنها مصادر مجمع عليها. And disagreeing on these four sources in particular is it's a disagreement that's not given any consideration, because he says over here these are sources that are agreed upon. But I think there'd be circular reasoning here, because that also entails that ijma' is already a proof, already a source. So that's why I think it's better to simply suffice on وَهَذِهِ الْمَصَادِرْ مَقْطُوعٌ بِهَا. These are conclusive. These four sources, they're conclusive, you see. And so because they're conclusive, you can't have disagreement, right? I believe that's a better way to express or present the argument. And then he says, okay, what about the others? The other topics that we mentioned, Amal Ahl, al-Madinah, al-Dhari'ah, and them. So he says, وَأَمَّا الْمَصَادِرُ الْمَعْدُودَةُ ضِمْنَ الْمُخْتَلَفِ فِيهَا. Now, what about these ones that are disagreed upon? Like كعمل أهل المدينة وسد الذرائع وشر من قبلنا, etc. Now, these ones that are disagreed on, what about them? فما يصح الاستدلال به منها راجع إلى الأدلة الأربعة المتفق عليها. That either these other sources, they either return to the four accepted conclusive sources of law. That's one possibility. Or أو لا يتجاوز كونه قرينة يرجح بها. Or these sources are actually qarina, they're contextual arguments that you apply on a case-by-case basis. That's, and you apply them in one scenario where it's appropriate, and you don't apply them in another scenario where it's not appropriate. And so they're not, strictly speaking, they're not usul, right? They're not usul per se, right? But rather they're applied contextually. They're applied contextually, because usul by their very nature, they, in principle, they're sort of, you can look at it as usul from the perspective that you establish their hujjiyah and you establish that they're a way to reason. But, in terms of, if you're looking at it from the perspective that you apply them unconditionally, then these are simply qara'in. And so what does he then do? So this is from Sheikh Hatim al-Awni, and, to summarize this particular section, what does he say? He says you have four conclusive sources: Quran, Sunnah, Ijma', Qiyas, and all the other sources, they either, you have two possibilities. They either return to the four conclusive sources, in which case they're also proof because they're going back to something else that's a proof in a conclusive source, or they're contextual arguments, qara'in. And then what he does is he now goes through those sources that are differed upon. The sources that are differed upon, now he goes through them individually. So he says, وَلِتَفْصِيلِ ذَلِكَ مَكَانٌ آخَرٌ. That, I'm not going to get into detail regarding all of this now. لكني أذكره هنا باختصار. However, I'll give you a summary. So this is his summary, right? So he goes through them one by one, and we'll do this. This is our bird's eye view of the chapter Adillatul Ahkam. So what does he say? First he discusses Amal Ahl al-Madinah. So he says فَعَمَلُ أَهْلِ الْمَدِينَةِ فِي زَمَنِ التَّابِعِينَ وَأَتْبَاعِهِمْ. So he's very particular on the time period as well. عَمَلُ أَهْلِ الْمَدِينَة in the early centuries, essentially. Yeah. How does he explain it? When is it a hujjah? When is it not? Or is it a hujjah? How does he explain it? He says ما كان من الأمور الدينية المعلنة المشهورة كالأذان فهذا من السنة. Right? فهذا من السنة. That those things that are like, those religious things that are widespread, they're common knowledge, like the adhan, right? Like the adhan, then that's from the sunnah. Why is it from the sunnah, right? So in other words, the source of evidence of Amal Ahl al-Madinah ultimately goes back to the fact that the sunnah itself is a source of evidence, right? So they're both connected, they're both attached, they both come hand in hand. So he says فهذا من السنة. Why? لأن خفاء السنة في مثل هذه الأمور على مجموع ذلك الجيل مستحيل. Because for a sunnah, for something like this to be hidden or to be unknown by by this early generation is impossible, or extremely unlikely. He says مستحيل, impossible, but Amal Ahl al-Madinah, depending on the issue at hand, can also be a probabilistic argument, you see. And again, we'll have a separate section on that, but a separate lesson on that. But what's important to note here is that the hujjiyah of Amal Ahl al-Madinah ultimately goes back to the sunnah. I like to call this the argument of traceability. That is the practice in question, can it be traced back to the Prophet sallallahu alaihi wasallam? If it can, then the evidentiary nature of it ultimately goes back to the authority of the Prophet sallallahu alaihi wasallam. If it doesn't, right? If it can't be traced back to the Prophet sallallahu alaihi wasallam, then it's not a hujjah. It's not an intrinsic proof, right? So that's Amal Ahl al-Madinah. Then he goes through Sadd al-Dhari'ah, and we've explained. Okay, we've explained all of these previously as well. In the previous slide. وَسَدُّ الذَّرَائِعِ غَيْرُ الْمَنْصُوصِ عَلَى سَدِّهَا, right? And he mentions Sadd al-Dhari'ah when it's not stipulated. When it's not stipulated in the Quran or Hadith, because you have examples where it is stipulated in the Quran and Hadith, and of course if it's stipulated in the Quran or Hadith, then you accept that because you accept the Quran and you accept the Hadith. But what about when it's not stipulated in the Quran or Hadith? How is it applicable then, if it is applicable? So he says, okay, a non-textual Sadd al-Dhara'i' المقبول منها هو من باب قاعدة درء المفاسد مقدم على جلب المصالح. That you have, what's accepted from Sadd al-Dhara'i' ultimately goes back to these two principles. The first قاعدة درء المفاسد مقدم على جلب المصالح, and the next قاعدة تدفع أشد المفسدتين بأخفهما. So you've got the first principle, which is that averting harm is prioritized over bringing about benefits. And this is like, a principle, maybe we'll discuss it in the lesson on Sadd al-Dhari'ah. And the other principle is adopting the lesser of two evils. Essentially, it's a principle of choosing the lesser of two evils. And so that's essentially, when you look at these two principles, how do they go back to Sadd al-Dhara'i'? Essentially, these two principles, they indicate a focus for consequences in law, and so for Sadd al-Dhari'ah as well, ultimately this goes back to the idea that if an act directly leads to something prohibited, then by way of consequences, that act would also be unlawful, with caveats in the discussion and the conditions that we'll discuss in the lesson itself. But what does he say? He says, he continues, he says, and these two principles that we've just discussed, that we've just mentioned, وَهُمَا قَاعِدَتَانِ شَرْعِيَّتَانِ مَرْجِعُهُمَا إِلَى أَدِلَّةِ الْكِتَابِ وَالسُّنَّةِ. That these two principles, they ultimately go back to the Quran and Sunnah. And so Sadd al-Dhara'i', the evidentiary nature of it, according to this, would ultimately go back to the Quran and Sunnah. I believe there's another way to argue this as well, and we'll discuss that in the lesson, inshallah. But he continues, and this is an important point, right? He says, وَلِذَلِكَ, right, based on this argument that he's just presented, وَلِذَلِكَ اتَّفَقَ الْعُلَمَاء عَلَى اعْتِبَارِ سَدِّ الذَّرَائِعِ فِي الْجُمْلَةِ وَإِنَّمَا يَخْتَلِفُونَ فِي التَّفَارِيعِ. That based on this, all scholars agree on the principle of Sadd al-Dhari'ah in general. in principle, meaning in principle they accept it. They only differ on application, right? They only differ on application. And so, that's al-Dhari'ah. Then we have the next principle, Shar Man Qablana, the laws of previous nations. What does he say for this? He says, لا يكون شرعا لنا إلا إذا ورد في شرعنا ولم ينسخه شرعنا. That it's not a law for us except if it's included within our text itself, within our law. So it's mentioned in the Quran or the Sunnah, and it's not abrogated. It's not abrogated. فَمَرْجِعُهُ إِذَنْ إِلَى الْكِتَابِ وَالسُّنَّةِ. Ultimately, it goes back to the Quran and Sunnah. How exactly does it go back to the Quran and Sunnah? We'll explain that in that lesson. But what he's saying over here is that ultimately it goes back to the Quran and Sunnah. It's not an independent source. It ultimately goes back to the authority of the conclusive sources. And then he mentions, and this is an important one, right? This is an important one. This is a very neat summary, right? A very neat summary. It's actually it's very rare to find the way it's Qawl al-Sahabi discussed in the way that it's mentioned over here, right? So وقول الصحابي فيما لم نجد فيه نصا إذا لم نعلم له مخالفا. Like as for the opinion of a companion, when we have no text regarding the particular issue, because otherwise we'll be adopting the text and Qawl al-Sahabi would not be the main discussion at hand. It'll be the text. So that's why he's included that caveat. And then the next, إذا لم نعلم له مخالفا, when we do not know there to be any disagreement, meaning there's not you don't have multiple opinions and you don't have companions disagreeing on the issue as well. In that case, what's the evidentiary status of that? How do you look at it? He says إما أن يدخل في معنى الإجماع السكوتي, right? مثل الفتوى المشتهرة لأحد الخلفاء الأربعة دون مخالف له من الصحابة. Either it's included within إجماع سكوتي, right? Included within, it's included conceptually, and of course you have to make an argument for this, but it's included in the principle of ijma', of consensus. That's one possibility. وإما أن يكون لقول الصحابي حكم المرفوع إلى النبي صلى الله عليه وسلم. Or the opinion ultimately goes back to the Prophet sallallahu alaihi wasallam, because it's not something you can independently conclude. It's something that's dependent on something they've heard from the Prophet sallallahu alaihi wasallam. And so he has the opinion has hukm al-raf'. That's what they call it. So ultimately, that's going. So the first is going back to ijma'. The second is going back to the authority of the Sunnah. And then the third possibility is what? أو أن يكون الأخذ به تقليدا لا استدلالا بقوله لأن الصحابي أولى بمعرفة الحق وإصابته في اجتهاده. Or the third possibility is that you're adopting it not as an intrinsic source of evidence, but rather by an appeal to authority, taqleed, right? Which is and that's not an issue. That's not an issue if you don't have a separate argument. And why is it not an issue? Because the companion is, he's the most likely to know, to be aware of the truth, right? Because he's directly living with the Prophet sallallahu alaihi wasallam. He's had a lived experience with the Prophet sallallahu alaihi wasallam. So if there's anyone who's going to understand revelation and what's expected and instructed by Allah Most High and the Prophet sallallahu alaihi wasallam, is going to be by the companions who lived with the Prophet sallallahu alaihi wasallam, who have insight to the very context of revelation that others don't. And so the taqleed of the companion is acceptable, but it's not considered in this context. It's simply it should be acknowledged as taqleed. In other words, what does that mean? In other words, if there's a scholarly debate between two people, right? So two jurists, they're discussing something, and someone adopts qawl al-sahabi by way of appeal to authority, because he's unsure, he hasn't concluded, he hasn't arrived at a conclusion yet, right? Now, in that debate with the other jurist, that won't be a binding evidence against them. That won't be a binding evidence against them, right? Rather, it just the binding evidence would be the conclusive sources and the other sources of law, unless qawl al-sahabi itself carries the meaning of ijma' or the authority of the Prophet sallallahu alaihi wasallam by way of hukm al-raf', that ultimately traces back to the Prophet sallallahu alaihi wasallam. Otherwise, it'll be taqleed that's only binding on those who don't have an argument, because of course, if you don't know something, you have to appeal to authority in the same way that a non-specialist has to appeal to authority if he is unable to arrive at a conclusion himself. And so in summary, فهو إما, so this qawl al-sahabi is إما, فهو إما إجماع, أو سنة أو يكون تقليدا واجبا في حق من لم يجد دليلا من الكتاب أو السنة أو الإجماع أو القياس القوي الظاهر المعارض لقول الصحابي. So unless either قول الصحابي is ijma' or sunnah or is taqleed that's necessary on someone who doesn't have an argument from other sources, right? And we'll get into this in more detail in the chapter of Qawl al-Sahabi, but this summary is very important. It's a very neat summary as well. So that's Qawl al-Sahabi. Then you have Istihsan. والاستحسان مرجع المقبول منه إلى الأدلة المتفق عليها. That when is Istihsan accepted? And we mentioned that there's some discussion on what Istihsan is. It's like there's a Qiyas or a general qaida principle, and you don't adopt that based on secondary considerations. So when is that accepted? When is Istihsan accepted? It's accepted if it ultimately goes back to the sources of law, right? That's when it's accepted. Then we have al-Maslahah Mursalah, which we discussed as well, we defined. وَالْمَصْلَحَةُ الْمُرْسَلَةُ التي يصح الاستدلال بها مرجعها إلى تحقيق مقاصد الشريعة المنصوص عليها. That when is it accepted? It's accepted when it conforms to the general the principles of the law that are stipulated in the Quran and Hadith. Ultimately, it goes back to the other sources of law as well. And then finally, we've got Ilham. I didn't mention this in the previous list because I didn't think it was necessary. But Ilham is basically just a form of inspiration, or sort of an inspiration that someone feels, that sort of it's like an innate feeling, a natural feeling that one thing is more correct than the other, but it's not something that can sort of make a rational argument for. So it's just like an innate feeling. Well, ilham laysa dalilan. In itself, it's not an evidence, right? It's not evidence. لكنه قرينة استئناسية قد يلجأ إليها المجتهد عند انعدام الأدلة والقرائن الأخرى. But it's just something that someone might use in the absence of all other evidence. فهو من أضعف القرائن الاستئناسية. Now this استئناس is not, it doesn't mean that it's an argument per se, but it's just something that let's just say you have two different opinions, and you're sort of you're unsure which side, which of the two opinions is stronger than the other. You're unsure, and so you have a natural inclination. Someone has ilham, for example, that which puts him which tips the scales in one way. He might use that, but that's not an argument per se, like as he says here, laysa dalilan. So you can't have like a juristic work, for example, and you say, okay, yeah, this is the case, and my argument is ilham. Like the opposing jurist will not accept that. Like that's not accepted, and so that's ilham. So over here, what we just mentioned in these two slides is a summary of all the sources that, and of course there's more detail to it. This is just a summary, and we'll get into the details in the lessons to follow, inshallah.